Hey everybody, thanks for watching. I'm Alan Lenczycki, an attorney up in Northern Illinois. I recently had a client, this sometimes does happen, who is very, very scared of going to court. Okay. That's a big part of my practice is I want to try to tell my clients, like, you're going to be fine. One advantage of having an attorney there is the attorney cares about you and tries to help you through this bad spot. But this client had a DUI case. She was an otherwise fantastic person, had never been in trouble before, and was a successful middle class, middle aged person and had this DUI. Very frightening experience. So, the jitters, if you have the jitters before you go to court, please understand that's normal. Okay. Everybody in that courtroom, unless you're a judge or a lawyer or a cop, doesn't want to be there. Okay. The judges and lawyers and cops, they're there all the time. They are used to it, and they're in a position of power and authority. And the people that are the arrestees, they're there because they got brought there by their ticket, their citation, or taken there in handcuffs. And nobody wants to be there. It's embarrassing, it's scary, and it's anxiety inducing because you sometimes don't know, like, what's going to happen to me, right? And the what's going to happen to me is what makes people have anxiety and fear. Okay. But everybody else is embarrassed too. Okay. I don't know if you've ever heard that tip about public speaking. Like, imagine the audience is in their underwear. I mean, everybody is just people. And all the other people in that gallery full of people, they're they don't want to be there either. They're terrified. They're embarrassed. Whatever. They're ashamed. So the lawyer can help them. I can't tell you how many times the clients are telling me, like, "Good to see you, man." They are when they see me at 9 o'clock in the morning or 9:05 sometimes, then they put a smile on their face because they know somebody's here to come and help me. Anyway, but what to expect on the first day of your DUI arraignment? Well, here's what that lady experienced is that you first get the arraignment is where the judge reads you your charges. You probably already know what you're charged with because you got tickets from the police the night or day that this happened. And the tickets, I mean, they're like a long printout and they're hard to read and understand. But an attorney can help you understand them. But often for a DUI, you get charged with one or two different types of DUI citations under one or two sections of the DUI code, okay, under the statute. And DUI is typically charged in one way if the person doesn't blow, and in two ways if the person does blow, because they can charge in the second part of the statute that they've also blown over 0.08 BAC. Okay. So if you see yourself, oh man, I only got pulled over once Friday night. How come I have two DUI tickets? Well, that's why. It's because they probably charge you under both sides of the statute. Okay. You'll also have your other tickets that you may have gotten uninsured, no stop sign, no turn signal, speeding, driving while license suspended. Those tickets suck. Okay. Talk to your attorney, but they're usually not as important in court as the DUI. The DUI is the 900-pound gorilla. The other tickets are not great. You don't want to be charged with speeding anytime. But compared to the DUI citation, it's small potatoes. Okay. So the judge is going to tell you what the official charges are. You may be surprised to hear that there's another one that you didn't hear of, or something's changed. Like, not so much in a DUI, but in something like a retail theft. Perhaps now they've charged you with trespassing too. That's BS. Well, they can do that. The charging attorney reviews it and decides what to charge you with, and they can charge you with whatever they want, basically within reason. So when this arraignment happens, the judge tells you what you're officially charged with, not just what the cop suggested. And the judge will tell you what the maximum penalties are. For DUI in Illinois, it's a class A misdemeanor. It's punishable by up to 1 year in jail and or a fine of $2,500. Ugh, okay. Now, in a first-time DUI, a misdemeanor DUI, you're probably not going to go to jail for a year. You're probably not going to go to jail for 2 hours, okay? But you've got to pay attention to it. That's the worst-case scenario, is that you could do this jail time, okay? And then lastly, the judge will talk to you about your attorney, okay? If you have a private attorney that you hired, let's say after you got the ticket, but before the first court date, that attorney should be there with you. If they're not, they better have a good excuse like, oh, I had a pre existing trip to Florida, so my associate's covering it or whatever. But the attorneys that are like, just go in there and get a date for me, those guys are clowns. I never do that. I think that looks terrible and whatever. I would never do that to a client. Never say never, but I haven't done that to a client and don't plan on it. Anyway, the judge will ask you, if you've got this private attorney, the attorney will start doing stuff, filing appearance. The attorney will maybe file a motion for discovery or perhaps a motion to challenge the stop of your car or the police officer getting you out of the car and asking you to blow in the breathalyzer machine. So the lawyer will start doing stuff or should start doing stuff. And if he doesn't, give me a call. Okay. But the public defender also could be appointed. If you tell the judge, look, judge, I didn't bring a lawyer because I can't afford one. Perhaps I'm off work. Perhaps I'm injured or sick, or I don't know. If you've got those conditions, you tell the judge and ask to see if you can qualify for a public defender. I've talked about public defenders before. Some of them are fantastic, very fine lawyers, and it's a great place for a young law student to go and learn how to be a lawyer. Some of those guys, though, are overwhelmed. They have too many cases, and they don't maybe give the attention to your case that otherwise maybe it ought to receive. Okay, I'll just leave it at that. But if you don't have any money, you tell the judge about your financial circumstances and ask for the appointment of a public defender. Because guess what? The public defender is tons better than trying to go it alone. You just about can't do it. Okay. After that, the judge will talk about discovery. Okay. Discovery means the evidence. Do the lawyers have the evidence? Usually on the first court date, at the arraignment date, nobody has anything. The state's attorney will say, I don't have it from the cops. And the defense lawyer will say, I don't have it from the state's attorney. So then the last thing that happens at your arraignment date is you get a date. Okay. And I don't mean like a date with that cutest girl in school to the ice cream social. No, I mean, you get a next court date. And typically the case is punted out approximately a month, either on motion of the defense lawyer, on motion of the state's attorney, or maybe by agreement. Often we'll say, yeah, by agreement, because nobody has anything and let's kick it out and see what happens the next month. Anyway, it's a lot of information. It can be stressful and overwhelming for somebody, especially if you're the defendant. You don't know what's going on, and it's your ass on the line, pardon me for saying that. So if you've got questions, you've got to call an attorney. Give me a call, Alan Lenczycki. Thanks a lot for watching. Take care.